my junior has checked up, and I find that the ERJ case that was cited, Delhi bench, that was taken up to the Supreme Court. But the Supreme Court set aside the judgment in view of the fact the order has already been complied with. Therefore, if that is set aside, I may hand up the judgment of the Supreme Court.
So the point of law is still open.
Yes, still open.
No, point of law, the judgment is...
From your point of view, point of law is what you say.
Yes.
But through this judgment, point of law is still open.
The Supreme Court decided that nothing remains.
I say...
when a judgment has been set aside, the entire
Sir, let one at a time. Yes, please.
The point of law, I submit, is closed, not open, because earlier Supreme Court judgments, they hold the field, and here the judgment which Mr. Bhattacharya was relying upon has been set aside. It says
on compliance. On compliance.
On compliance. Because if your lordship sees...
On compliance.
On compliance.
It doesn't say that the jurisdiction is decided.
One more question to all of you. What about the special bench of our High Court, which says that even if there is a modification of this thing by the appeal court, then also the first court gets to
modification. That is in view of Rule 15 of the contempt of court rules of this High Court,
which will not be attracted so far as a merger in respect of a judgment with the Supreme Court's judgment.
Because Rule 15 of the contempt of court rules of the Calcutta High Court specifically saying...
Because special bench is also binding on us.
Yes. Special bench is also binding on us because special bench has decided it on the view of Rule 15. Therefore, this question, which we are now canvassing before your lordship, has nothing to do with
that question was also before the special bench.
Modification of the division bench.
My lord,
no.
If I may...
Clause 2 says modification.
I am a state father. Supreme Court judgments are placed, even of 2025, which says, even in case of affirmation, this is much. 3 aspects. If it is
affirmed, modified,
or
reversed.
Merger.
In all the cases.
But untouched, if the special petition is not taken on board, not admitted, then another.
Yes. Then, Lord,
so the test will be whether or not a review is available to us. If a review is available to us, then we can enforce it.
Yes.
If review is not available to us, then it ceases to exist, and it ceases to exist for all practical
all practice.
That is your submission.
Yes. And Lord, one more thing before I...
There cannot be reply to reply. No,
right.
Don't provoke him, please.
Show that the judgment supports
me. All judgments support him. What can I do?
All judgments support the respective parties. Very good.
But only one more thing. That your lordship's pleasure was to hear Mr. Bhattacharya on Article 215 of the Constitution
and to 129.
129. Now, kindly have a look at those 2 provisions. I don't know how this is of any relevance in our case, because these really give jurisdictions. If I may just take your lordship's time for...
একটা constitutional বই দিন পেয়েছে ঠিক আছে আমি পেয়েছি ঠিক আছে আচ্ছা আমার কাছে
kindly see 215 high courts to be courts of record. Every high court shall be a court of record
Same words used in 129.
And shall have all the powers of such a court.
What is your what do you want to submit?
Including the power. It includes the High Court with the power. General power. But when the Supreme, I want to say that under Article 141 of the Supreme Court says it's also law. Therefore, the law laid down by the Supreme Court is also holding the field.
Yes.
Therefore, when the Constitution simply says that High Court will have power as a court of record, Supreme Court will have the power as a court of record, it does not say under what circumstances and who will have jurisdiction. Jurisdiction aspect is not dealt with either by 129 or by 215. I never say that the High Court does not have any power to punish for contempt because it's a court of record. But I say when it merges with the order of the Supreme Court, where
As I see it, if it was an act of contempt on the face of the court, like here is a contempt.
If I just say something,
So then we could have intervened and should have intervened, notwithstanding our judgment getting merged with the Supreme Court.
Certainly.
Now, whether on the principle of merger, whether we get denuded of our jurisdiction is something we will consider.
Grateful to you.
Now, my lord, can I make submissions, my lord?
Please, yes.
Yes. Now, my lord, kindly see first judgment, that is the Rampal and another versus G.S. Balla, which Mr. Sengupta has already submitted that the judgment has been set aside. Now,
Right.
the question has come from, fallen from your lordships. The laws are there. The number one is, when a judgment is set aside, it's entirely set aside.
Yes.
Number two, if the points were required to be left open by the Supreme Court while setting aside of the judgment, would have written the points were left open.
Right.
Lord, normal cases is this, when a SLP is dismissed or Lord, any even at the admission stage it is dismissed, the Supreme Court keeps the point open to decide later on. But here, Lord, there is no Lord, the order which has been placed before the lordships of the Supreme Court, no points were left open.
Very well.
Therefore, there is number three is this. My lord, when a judgment is set aside, my lord, with great respect, my lord, there cannot be any dichotomy of the judgment, the dichotomy of the order, that whether this part has been remained or this part. Mariamat Namah, 16 online, 4121, 17 December 2016. But my lord, although no appeal has been preferred against this order, but by a subsequent judgment of that Kerala High Court, in the case, kindly hand over the judgment, please. Who is there? Kindly hand over the judgment. Amit Matthew.
Yes. Mariam.
Amit Matthew, please. Amit Matthew, my lord. Kindly come to paragraph 9 of that judgment.
আরেকটা ধারের কপি ও এটা দিয়েছো হ্যাঁ সরি
Availability for getting the justice is one is statutory appeal, another is the constitutional provision. Now, Lord, which will prevail? Certainly, Lord, 136, kindly see this, 136 of the Constitution of India, may I just read? That is
Mr. Banerjee, we will be now facing a technical glitch.
What technical glitch?
Your audio might get off.
Oh, sorry, Mary.
Normally it is done. That is when I appear.
No, it's means, your lordships are not here. Am I not? I am not audible.
Yes, up to now, yes.
No, need not be worried. I have enough stock.
Yes, very good. Then Mr. Basu, yes, sir.
I will take only 1 minute.
Yes,
Two
sir.
judgment has been cited. Well,
Yes.
if your lordship look to the Gajal brothers judgment, my lord will find that honorable three judges bench says when it is travelled to Delhi and it is granted leave, the order under appeal is erased. If it is erased, my lord, what is to be executed?
Right.
This
We'll
is
consider
decided
that. We have to consider it. We'll
and
consider.
the two single judges, the Kerala High Court judgment, other judgment cited with the judge cannot have any overriding effect of the Supreme Court judgment.
Naturally.
That's all.
Right. Yes, sir. Just one sentence on the
One
side news.
judgment shown.
Yes.
If my permission to read the order without carefully, this was an appeal from the punishment imposed under the contempt jurisdiction.
This issue was not decided.
Not decided. On the contrary, I would say that the jurisdiction is in fact affirmed. The Supreme Court didn't say that it didn't have any jurisdiction to impose punishment. Just without, and then without the
If it did not decide the issue, then either side of the divide, it didn't decide.
I humbly submit to logically, this issue now has been affirmed by the Supreme Court that the contempt jurisdiction exercised was right. And then say the last line, we have been apprised by Mr. Dayal, learned counsel for the respondent, that the appellant had long been complied with the order. Taking note of the aforesaid, we are of the considered opinion that there is no justification to impose any kind of punishment on the appellants, and accordingly, judgment and order passed by the High Court as imposing punishment is set aside. If any proceeding relating to contempt is pending before the High Court, it shall be deemed to have been disposed of. The court doesn't say the High Court didn't have any jurisdiction even to entertain.
There is no occasion. There is no occasion to decide.
My lord, just kindly excuse me, my lord, for 1 second. Kindly excuse me, my lord. I am just seeing the only Mr. Saptangshu Basu's place, not the court. Now, my lord,
That is the technical glitch. That is the technical glitch we are talking about.
my lord, kindly see. My lord, kindly, just 1 minute. Kindly, my lord. I have argued. Kindly, this is kindly take note of that. I have argued that in the Supreme Court judgment, points were not left open. If the points were not left open, the question of deciding the question again does not arise in view of that judgment.
Very good. Heard learned senior advocates appearing for the alleged contemners, full stop. Heard learned senior advocate appearing for the petitioner, full stop. Next part. Hearing concluded, judgment is served.
Now, Mr. Basu has managed something, therefore his place is coming down.
Sorry, please, Dada.
His hand is so long. His hand is so long. There he goes.
Same side হয়ে যাচ্ছে
সবাইকে ছেড়ে আমাদের
Grateful to Again, Saptangshu Basu.
grateful to Dada also.